ਦ ਵੇ ਫਾਰਵਰਡ ਵਿੱਚ ਤੁਹਾਡਾ ਬਹੁਤ-ਬਹੁਤ ਸਵਾਗਤ ਹੈ। ਮੈਂ ਤੁਹਾਡਾ ਹੋਸਟ ਹਰਜੋਤ ਸਿੰਘ। ਸਾਡੇ ਵਿਊਅਰਸ ਕਈ ਵਾਰ ਸਾਨੂੰ ਇਹ ਡਿਮਾਂਡ ਕਰਦੇ ਨੇ ਕਿ ਅਸੀਂ ਇਸ ਮੁਲਕ ਵਿੱਚ ਬਜ਼ੁਰਗਾਂ ਵਾਸਤੇ ਜੋ ਪ੍ਰੋਟੈਕਸ਼ਨਸ ਹੈਗੇ, ਜੋ ਗਵਰਨਮੈਂਟ ਦੇ ਪ੍ਰੋਗਰਾਮਸ ਹੈਗੇ, ਉਹਨਾਂ ਬਾਰੇ ਗੱਲ ਕਰੀਏ। ਸਾਨੂੰ ਇਹ ਸਮਝਣ ਦੀ ਲੋੜ ਹੈ ਕਿ ਇਸ ਕੰਟਰੀ ਵਿੱਚ ਬਹੁਤ ਸਾਰੇ ਵੈਲਫੇਅਰ ਪ੍ਰੋਗਰਾਮਸ ਹੁੰਦੇ ਨੇ, ਲੋਕਾਂ ਦੇ ਬੈਨੀਫਿਟ ਦੇ ਪ੍ਰੋਗਰਾਮ ਹੁੰਦੇ ਨੇ, ਜਿਨ੍ਹਾਂ ਬਾਰੇ ਸਾਨੂੰ ਪਤਾ ਨਹੀਂ ਹੁੰਦਾ ਔਰ ਅਸੀਂ ਉਨ ਬੈਨੀਫਿਟਸ ਤੋਂ ਡਿਪਰਾਈਵਡ ਰਹਿ ਜਾਂਦੇ ਹਾਂ। ਅੱਜ ਅਸੀਂ ਉਨ ਬੈਨੀਫਿਟਸ, ਉਨ ਲਾਜ਼ ਦੇ ਬਾਰੇ ਗੱਲ ਕਰਾਂਗੇ ਜੋ ਪਾਰਟਿਕੂਲਰਲੀ 65 ਸਾਲ ਤੋਂ ਉੱਪਰ ਜਿਹੜੇ ਸਾਡੇ ਬਜ਼ੁਰਗ ਹੈਗੇ ਉਹਨਾਂ ਵਾਸਤੇ ਗਵਰਨਮੈਂਟ ਰਨ ਕਰਦੀ ਹੈ। ਅੱਜ ਅਸੀਂ ਬੜੇ ਸ਼ੁਕਰਗੁਜ਼ਾਰ ਹਾਂ ਔਰ ਖੁਸ਼ ਨਸੀਬ ਹਾਂ ਕਿ ਸਾਡੇ ਵਿੱਚ ਅੱਜ ਮੌਜੂਦ ਹਨ ਜੱਜ ਡੇਵਿਡ ਕ੍ਰਿਸ਼ਬਲਮ, ਜੋ ਕਿ 24 ਸਾਲ ਵਾਸਤੇ ਕੁਈਨਸ ਫੈਮਿਲੀ ਕੋਰਟ ਵਿੱਚ ਜੱਜ ਰਹੇ ਨੇ। ਉਹਨਾਂ ਨੇ ਰੀਸੈਂਟਲੀ ਉੱਥੋਂ ਰਿਟਾਇਰਮੈਂਟ ਲਿੱਤੀ ਹੈ ਔਰ ਆਪਣੀ ਪ੍ਰਾਈਵੇਟ ਪ੍ਰੈਕਟਿਸ ਵਿੱਚ ਆਏ ਨੇ। ਕ੍ਰਿਸ਼ਬਲਮ ਟੇਬਰ ਪੀਸੀ ਕਰਕੇ ਉਹਨਾਂ ਦੀ ਲਾਅ ਫਰਮ ਹੈਗੀ ਹੈ, ਜਿਸ ਦੇ ਵਿੱਚ ਉਹ ਐਕਸਕਲੂਸਿਵਲੀ estate planning, family law ਤੇ matrimonial law ਦੀ practice ਕਰਦੇ ਨੇ। Judge, thank you so much for taking out the time coming to the studios today.
Thank you for having me. It's my pleasure.
Mr. David Kirshblum, ਜਿਸ ਤਰ੍ਹਾਂ ਮੈਂ ਤੁਹਾਨੂੰ ਦੱਸਿਆ ਹੈ ਕਿ ਉਹ estate planning ਦੀ ਪ੍ਰੈਕਟਿਸ ਕਰਦੇ ਨੇ ਔਰ 24 ਸਾਲ ਉਹਨਾਂ ਨੇ ਕੁਈਨਸ ਫੈਮਿਲੀ ਕੋਰਟ ਵਿੱਚ ਪ੍ਰੈਕਟਿਸ ਕੀਤੀ ਐਜ਼ ਅ ਜੱਜ। ਸੋ ਇੱਕ ਬੜਾ ਹੀ ਵਾਈਡ ਉਹਨਾਂ ਕੋਲ ਐਕਸਪੀਰੀਅੰਸ ਹੈਗਾ ਔਰ ਸਾਡੀ ਕਮਿਊਨਿਟੀ ਦੀ ਪ੍ਰੋਬਲਮਸ ਨੂੰ ਉਹ ਸਮਝਦੇ ਨੇ, ਕਿਉਂਕਿ ਉਹਨਾਂ ਨੇ ਕੁਈਨਸ ਕਾਊਂਟੀ ਵਿੱਚ ਮੋਸਟਲੀ ਆਪਣੀ ਜੱਜਸ਼ਿਪ ਕੀਤੀ ਹੈ। ਸੋ ਹੀ ਹੈਜ਼ ਦ ਐਕਸਪੀਰੀਅੰਸ, ਹੀ ਹੈਜ਼ ਦ ਐਕਸਪੋਜਰ। ਜੱਜ, for the benefit of our community, our community is still new in this country. There are a lot of differences in laws and culture, which you can very well appreciate. Before we talk about anything substantial, I would like you to tell us, what is estate planning? What do we mean by estate planning?
And I thank you for that question. Just as a matter of background, I appreciate also you mentioning the fact that I presided in Queens County. Queens County, and I had gone on many lecture tours as well as conventions nationwide with other members of the judiciary. Queens County is the most eclectic population in the entire United States. The family court and other courthouses in New York State have a body of interpreters, but the amount of interpreters that were needed for Queens County was more than any other. We had from every single population, every single country. We are all immigrants to this fine United States of America. We all are, including myself and my family, who my grandparents were born in Poland. So I'm certainly appreciative of the fact that your community, who I got to know under circumstances sometimes that were not so pleasant as a family court judge, but I had many people from your population before me. And I also had one colleague of mine who was also from your community and got to know her over time. And I certainly am very appreciative of your culture, of your tradition, of your family values, of your love for each other, as well as for your entrepreneurship. I'm intrigued by the fact that your community is hardworking and sincere and conscientious in wanting to do everything they can to make themselves profitable and successful and to be able to provide for their family. So it really transmits a message that I identify with, and therefore, again, it's my pleasure to be on this program. Insofar as the elder law and trust and estates, it sometimes is misidentified. We are today going to be concentrating on care for the elderly, but trust and estates, my partner and I specialize in for the adult population, the senior population, even my children who are now married with small children. We also address issues for younger people because everyone should have instruments, written instruments, where they identify where they want, heaven forbid, if something happens to them, where they want their children raised. As someone who comes from the court system of over 24 years, I say right now, and I would have said it when I was on the bench as well, any way to try and address issues and not needing the court to make decisions for you, it's always better to do it on your own. And to that extent, having written instruments and all the documents that we're going to be talking about today, it is always better to pre-plan. We have in Kirshblum Tabor two types of clients. We have clients who identify the seriousness and say, before something happens, we want to address it by meeting with a lawyer and having everything planned for us. And then unfortunately, we have others who come to us at a late hour and say either someone has passed or someone is very sick or someone hasn't done the planning that they need. What can we do now? And we try to identify both. But in the perfect world, and certainly this is not a perfect world, but in the perfect world, it is always better to pre-plan circumstances such as this, because we're talking about an area of law that unfortunately is not so happy. It's not like purchasing real estate, or it's not such as some of the things that we did in family court that were the only happy things, adoptions of children. We're talking about when people get sick, people get incapacitated, and unfortunately when people die. And identifying those issues and making sure that the instruments that the parties have in advance of or during protect their interests and also protecting the interests of their children. I want to just say one other thing to that extent. To the extent that we are talking about, and my phones will continue to ring, and I apologize for that. It's a good thing. But to the extent that we have a vast population of clientele, we certainly want for everyone to be welcome, and we certainly welcome your population for that purpose.
David, thank you so much for the kind words for the community. Yeah, as I said in the beginning, you have a lot of exposure to the community, both the good side and the bad side, being in that court. Our community arrived in 70s and 80s. They have worked hard for themselves and have made some gains, accumulated some assets, some wealth, and now, as nature has it, this is a time for many to pass those properties to the future generations. A very important part of what we are about to talk today is, what do we do? What's the best way to pass on those properties? Because there are a lot of implications, there are tax implications and other factors which decide what would be the best thing to do. But before I go there, again, going back to my first question, estate planning. So we understand it's the planning of how do our assets go to our future generations, or whatever. You'll give us the details. But I want to ask you something in the beginning. Is it something only for the rich people, or is it something that every human being, just by virtue of being alive, has to worry about?
I think that's a great question. Certainly the rich have the means to have the lawyers that will accommodate them and service them and protect them from lawsuits, protect them from having to pay taxes that could very well be upwards of 50 to 60% of their net worth. They have the wherewithal to pay lawyers to do that. But we should take an example of that from them, that even for those who don't have that kind of wealth, anybody who has worked hard in their lifetime to accumulate anything, whether it's just one primary residence, whether it is one type of business, they work very hard. And when you talk about a population such as yours that have come to this country with pretty much nothing and taken from that and build with hard work, with 24/7 care and concern to conduct their business while also maintaining their family, it would be terrible. It would be tragic, truly, for them to not have the necessary tools and instruments to protect them as well, and also to ensure, and I say this as a true, honest, sincere citizen of this country who pays his share of taxes, but there's a difference between paying taxes that are mandatory on your income and doing what you need to do to ensure that you don't have to pay as much as you would have if you just planned. Capital gains tax, for instance, estate tax, other types of taxes. There are ways that the rich certainly, but even those who aren't rich, should be availing themselves of what is necessary to ensure that instead of giving the money to Uncle Sam, they end up being able to give that money to their beneficiaries, to their descendants, to their surviving spouses. And so therefore, this is not an area of law for the rich. This is an area of law for everyone. And to the extent that even for those who don't have real property. But as my partner and I always recommend, as part of our asset management and our planning, every single person should have a power of attorney and a healthcare proxy. I know we're going to get into those documents specifically in a moment, but it's so important. I can't stress enough, because we unfortunately, especially during COVID, had situations where family members were being taken to the hospital and doctors were not then calling next of kin. Unless someone has a healthcare proxy and authorizes their family member or an agent, it could be someone that's not a family member, to be able to speak on their behalf if by chance, while in the hospital, they go into some kind of status where they are not able to make decisions for themselves. They need someone to be able to make the decisions for them. And doctors will look for a healthcare proxy to see if they have that authorization to speak to someone else. And in the absence of it, they will make the decisions that they feel are best, which usually is the best decision, but family members should be consulted. Family members should participate, especially when someone's not able to speak for themselves. And similarly, when it comes to a power of attorney. And that could be because of someone who is becoming medically unable to make financial decisions. And these two documents are specifically not for the deceased. These are documents that are for the living, that if someone has to make financial decisions, it could even be someone who's out of the country and has authorized through a power of attorney for someone else to be able to speak on their behalf, to be able to act on their behalf as their agent, to go into a bank, to make a wire transfer, to go into business accounts and be able to make the transactions that are necessary when someone else is either in transit or abroad. These are the two most important instruments beyond, of course, all of the estate planning that we do for those who have a lot and those who don't have a lot. And we do for both.
Yeah. We will go more into details of these documents, but what I want my community, the viewers, to listen and understand at this time is कि जिदा कि जज ने दस्या कि सिर्फ ਜਿਹੜੀ ਸਟੇਟ ਪਲੈਨਿੰਗ ਹੈ ਉਹ ਸਿਰਫ ਅਮੀਰਾਂ ਵਾਸਤੇ ਨਹੀਂ ਹੈ, ਹਰ ਬੰਦੇ ਨੂੰ ਇਸ ਦਾ ਫਾਇਦਾ ਚੱਕਣਾ ਚਾਹੀਦਾ ਔਰ ਇਹ ਪਲੈਨਿੰਗ ਕਰਨੀ ਚਾਹੀਦੀ ਹੈ, ਕਿਉਂਕਿ ਤੁਸੀਂ ਜਿਹੜੀ ਪੈਸੇ ਇਸ ਮੁਲਕ ਵਿੱਚ ਕਮਾਉਂਦੇ ਹੋ ਤੁਸੀਂ ਆਪਣੇ ਵਾਰਸਾਂ ਨੂੰ, ਆਪਣੇ ਡਿਸੈਂਡੈਂਟਸ ਨੂੰ ਦੇਣਾ ਚਾਹੁੰਦੇ ਹੋ, ਉਸ ਦੇ ਵਿੱਚ ਤੁਸੀਂ ਟੈਕਸ ਦੇ ਪੈਸੇ ਬਚਾਣੇ ਨੇ। ਹੋਰ ਉਸ ਦੇ ਇਲਾਵਾ ਆਪਣੇ ਜੀਤੇ ਜੀ ਵੀ ਤੁਸੀਂ ਇਹ ਆਪਣੀ ਜਿਹੜੀ ਲਾਈਫ ਹੈ ਉਸ ਨੂੰ ਕਿਸ ਤਰ੍ਹਾਂ ਇਨ ਲਾਜ਼ ਦਾ ਫਾਇਦਾ ਚੱਕ ਸਕਦੇ ਹੋ, ਉਹ ਅਸੀਂ ਉਸ ਦੇ ਬਾਰੇ ਜ਼ਿਆਦਾ ਗੱਲ ਕਰਾਂਗੇ। ਬਹੁਤ ਜ਼ਰੂਰੀ ਹੈ, ਬੜੀ ਕਲੋਜ਼ਲੀ ਸੁਣਿਓ। ਅਸੀਂ ਇਹ ਗੱਲ ਕਰਦੇ ਹਾਂ ਇੱਕ ਛੋਟੀ ਜੀ ਬ੍ਰੇਕ ਦੇ ਬਾਅਦ। The Way Forward is ਤੁਹਾਡਾ ਫਿਰ ਤੋਂ ਸਵਾਗਤ ਹੈ। ਮੈਂ ਤੁਹਾਡਾ ਹੋਸਟ ਹਰਜੋਤ ਸਿੰਘ। So David, before going to the break, you mentioned health proxy and power of attorney. We will speak about the instruments that a person needs after he or she dies, right? For the property to be taken care or go to the descendants. But before that, while they're living. So you spoke of health proxy and power of attorney. Can you tell us in a little more detail, what is a health proxy?
Yes. So a healthcare proxy is a document that each individual should have and that we draft for individuals. A husband and wife cannot have one healthcare proxy. Each of them have to have their own. And in it, they will specify, there could be a very general document where they say, whatever decision making that I have, I now transfer that authority to someone else. They are known as the principal. And it's a principal agent type of relationship where they are then designating an agent. It could be more than one agent. I have a son who is a dentist with a medical background. So for me and for my wife, he actually is our primary healthcare proxy agent. Insofar as other family members, you can have them as co-agents, or in the alternative, you could have them as successor agents. When do these documents come into play? Again, if someone ends up in a hospital, they're not able to speak for themselves, and as a result, the doctor is looking for answers or guidance from the family as to what ultimately they want. We had as part of the whole COVID process. And as much as I mentioned the fact that I was on the bench for 24 and a half years, with my partner, we were still doing work under her prior corporation. During the height of COVID, when March 19, 2020 came about, people who are absolutely healthy all of a sudden became sick. There was no foreseeability, there was no way to forecast, and they ultimately became unable to breathe, unable to function, and they were being rushed to the hospital. We had many occasions where family members were calling us with ambulances on the way to their home and saying, the hospital is not going to allow me in. I need to make sure that the hospital, the doctor, the nurse will contact me and let me know, A, what's going on, and B, if a decision has to be made for me to be able to do so. And so we were running to these hospitals. We had several occasions where we were executing with the ambulance, having the patient, the client, if you will, on a gurney, but they still had consciousness, and they were signing the documents. We were having them witnessed and having them notarized. And then we would make sure that it was sealed, it was put with the patient, the EMT or the ambulance service knew that when they brought the patient into the hospital, that this document has to be shown to the check-in area of the hospital. And hospitals then were on notice that if anything were to happen where family, next of kin, or someone else, a third party, needed to be contacted, they would have that information. In the healthcare proxy, it has not only, of course, the name of the agent, the address of the agent, but also the cell phone of the agent and any other numbers that they want to provide. And what we do is we make sure that those agents also are aware of their responsibilities to be able to perform their duty in the absence of the patient being able to make those very important decisions. And it could be as simple as whether someone wants to have one type of surgery or another, medication, to know that there would also be, and hospitals are very good, especially in these times, to be able to have medical background and look up in patients' files to see whether they're allergic, for instance, to penicillin or certain other types of symptoms or things that they should be on notice of. But it's always more helpful for once decisions having to be made, they could be minor, they could be major, to have someone that they can contact and say, we saw the healthcare proxy, we're contacting you as a result, and we're just letting you know, A, what's happening, which they don't have a duty to do otherwise, and B, here's a decision that we're contemplating, and we'd like to hear what you say, since the patient has authorized you to speak on their behalf.
So in absence of a health proxy, does the spouse have that power to take the decision? Or
they do not have an inherent right just because they have a certificate of marriage. Any spouse who says, I am married to my husband, so therefore when he becomes incapacitated, I could speak for him, is wrong. They do not have that inherent power. Some husbands might say they don't want their wife to make the decision. They might rather have a third party make that decision, someone with a medical background. But that's a case-by-case situation. But there is no automatic right by a spouse to speak for their spouse. My wife likes to speak on my behalf on more than many occasions, but insofar as medical determinations, they do not have that inherent right. They need authorization.
ਅਸੀਂ ਤੁਹਾਨੂੰ ਦਸੀਏ ਜੋ ਜਿੱਦਾਂ ਕਿ ਹੁਣੇ ਡੇਵਿਡ ਨੇ ਦੱਸਿਆ ਹੈਲਥ ਪ੍ਰੌਕਸੀ ਹੈ ਕਿ ਤੁਸੀਂ ਆਪਣੇ ਜੀਤੇ ਜੀ ਇੱਕ ਇਨਸਟਰੂਮੈਂਟ ਸਾਈਨ ਕਰਦੇ ਹੋ ਤੁਸੀਂ ਦੱਸਦੇ ਹੋ ਕਿ ਅਗਰ ਮੈਂ ਕਦੀ ਐਸੀ ਸਿਚੁਏਸ਼ਨ ਵਿੱਚ ਹੋਵਾਂ ਐਸੀ ਮੈਡੀਕਲ ਸਿਚੁਏਸ਼ਨ ਵਿੱਚ ਜਿੱਥੇ ਮੈਂ ਆਪਣਾ ਡਿਸੀਜਨ ਨਹੀਂ ਲੈ ਸਕਾਂ ਆਪਾਂ ਸਾਰਿਆਂ ਨੇ ਦੇਖਿਆ ਕਿ ਕੋਵਿਡ ਵਿੱਚ ਚੰਗੇ ਭਲੇ ਹੈਲਦੀ ਬੰਦੇ ਆਲ ਆਫ ਅ ਸਡਨ ਦੇ ਫੈਲ ਸਿਕ ਔਰ ਉਸ ਤੋਂ ਬਾਅਦ ਉਹ ਇਸ ਪੋਜੀਸ਼ਨ ਵਿੱਚ ਨਹੀਂ ਸੀਗੇ ਕਿ ਉਹ ਆਪ ਡਿਸੀਜਨ ਲੈ ਸਕਣ ਕਿ ਸਾਡੇ ਨਾਲ ਅੱਗੇ ਕੀ ਕਰਨਾ ਚਾਹੀਦਾ ਕਈ ਵਾਰ ਡਾਕਟਰਾਂ ਨੂੰ ਕਈ ਪ੍ਰੋਸੀਜਰਸ ਵਾਸਤੇ ਪਰਮਿਸ਼ਨ ਲੈਣੀ ਪੈਂਦੀ ਹੈ ਤੇ ਜ਼ਰੂਰੀ ਨਹੀਂ ਹੈ ਕਿ ਤੁਹਾਡੇ ਜਿਹੜਾ ਸਪਾਊਸ ਹੈ ਹਸਬੈਂਡ ਔਰ ਵਾਈਫ ਉਹ ਡਿਸੀਜਨ ਲੈ ਸਕੇ ਉਹ ਡਿਸੀਜਨ ਉਹ ਬੰਦਾ ਲੈਂਦਾ ਹੈ ਜਿਸ ਨੂੰ ਕਿ ਤੁਸੀਂ ਅਪਾਇੰਟ ਕਰਦੇ ਹੋ ਤੁਸੀਂ ਕਹਿੰਦੇ ਹੋ ਕਿ ਇਹ ਜਿਹੜਾ ਬੰਦਾ ਹੈ ਇਹ ਮੇਰਾ ਹੈਲਥ ਪ੍ਰੌਕਸੀ ਹੈ ਇਸ ਨਾਲ ਤੁਸੀਂ ਰੈਫਰ ਕਰਨਾ ਹੈ ਉਸ ਨੂੰ ਜਿਹੜੇ ਡਾਕਟਰਸ ਹੈਗੇ ਉਹ ਇਮੀਡੀਏਟਲੀ ਉਸ ਨੂੰ ਇੰਟੀਮੇਟ ਕਰਦੇ ਨੇ ਉਸ ਨੂੰ ਦੱਸ ਦੇਣ ਕਿ ਬਈ ਇਹ ਤੁਹਾਡੇ ਜਿਹੜੇ ਇਹ ਬੰਦੇ ਹੈਗੇ ਇਸ ਮੈਡੀਕਲ ਸਿਚੁਏਸ਼ਨ ਵਿੱਚ ਹੈਗੇ ਤੇ ਦੱਸੋ ਅਸੀਂ ਕੀ ਕਰਨਾ ਹੈ ਇਹ ਤੁਸੀਂ ਸਮਝ ਸਕਦੇ ਹੋ ਕਿ ਇਸ ਮੁਲਕ ਵਿੱਚ ਇਹ ਕਿੰਨਾ ਇੰਪੋਰਟੈਂਟ ਹੈਗਾ। ਅਸੀਂ ਕਈ ਵਾਰ ਐਸੀ ਜਗ੍ਹਾ ਤੇ ਹੁੰਦੇ ਆ ਜਿੱਥੇ ਸਾਡੇ ਨਾਲ ਉਹ ਫੈਮਿਲੀ ਮੈਂਬਰਸ ਜਾਂ ਕੋਈ ਨਾਲ ਨਾ ਹੋਏ, ਜਾਂ ਕਈ ਵਾਰ ਫੈਮਿਲੀ ਮੈਂਬਰਸ ਦੇ ਹੋਣ ਦੇ ਬਾਵਜੂਦ ਸਾਨੂੰ ਐਸੇ ਬੰਦੇ ਦੀ ਲੋੜ ਪੈਂਦੀ ਹੈ ਜੋ ਰਾਈਟ ਡਿਸੀਜਨ ਲੈ ਸਕੇ। ਜਿਸ ਤਰ੍ਹਾਂ ਇਨ ਜੱਜ ਸਾਹਿਬ ਨੇ ਆਪਣਾ ਬੇਟਾ ਜੋ ਕਿ ਇੱਕ ਡੈਂਟਿਸਟ ਹੈ, ਐਟਲੀਸਟ ਇੱਕ ਮੈਡੀਕਲ ਪ੍ਰੋਫੈਸ਼ਨਲ ਹੈ, ਉਹਨੂੰ ਆਪਣੀ ਹੈਲਥ ਪ੍ਰੋਕਸੀ ਇਹਨਾਂ ਨੇ ਦੱਸਿਆ ਕਿ ਬਣਾਇਆ ਹੋਇਆ ਹੈ, ਤੇ ਇਹ ਬਹੁਤ ਇੰਪੋਰਟੈਂਟ ਹੈ। ਅਸੀਂ ਆਪਣੇ ਸਾਰੇ ਵਿਊਅਰਸ ਨੂੰ ਅਰਜ ਕਰਦੇ ਹਾਂ ਕਿ ਇਹ ਜਿਹੜੀ ਹੈਲਥ ਪ੍ਰੋਕਸੀ ਹੈ ਇਸ ਨੂੰ ਜ਼ਰੂਰ ਕੰਸੀਡਰ ਕਰਨ। ਹਰ ਬੰਦੇ ਨੂੰ ਇੱਕ ਹੈਲਥ ਪ੍ਰੋਕਸੀ ਜਿਹੜੀ ਹੈ ਉਹ ਅਪਾਇੰਟ ਜ਼ਰੂਰ ਕਰਨੀ ਚਾਹੀਏ। ਡੇਵਿਡ, after having spoken about health proxy, I would like to ask you, what is a power of attorney?
So a power of attorney, like a healthcare proxy, is a document that is maintained and has controlling power during the person's lifetime. Again, it is a principal-agent relationship. Someone such as myself would then authorize someone else to be able to speak on my behalf. There's a checklist that we have in our power of attorney. You should be mindful. A lot of people oftentimes think they can pull a power of attorney off the internet, save themselves some money, and utilize it. The power of attorney has changed in the year 2020 July, so I would be mindful not to just pull something off the internet. It might not comply with present New York statute. But the the power of attorney is a necessary document so that if someone once again became incapacitated, now when it comes to financial decisions, not medical decisions, they are authorizing someone else to do those types of decision-making powers. I go back to myself. I have my son who's the dentist, who is my healthcare proxy. When it comes to financial decisions, I have a son who is a lawyer. So he is my power of attorney agent, and my wife is as well, of course. And oftentimes our clients do pick the spouses. So therefore, when we do powers of attorney, we have the principal, say the husband, authorizing his wife and possibly someone else if they choose, like a child, if they're adult or otherwise. I would strongly not only urge not to pick as an agent a minor because they don't have that authority, but even if you contemplate that this won't come into effect until years, I would strongly recommend never pick as an agent a minor. But for the purpose of the power of attorney, as I said before, it is really when someone is either incapacitated or if someone is not able to make decisions because of logistics. My wife and I hope to be traveling this coming summer abroad, and I have a power of attorney. If by chance something happens, we run out of money, we need a wire transfer, something happens in our home and there has to be payments made to a contractor or to an electrician or to someone else, I have authorized someone else to be able to access my funds, make the payments that are necessary, and make the decisions that are necessary. And so therefore, the power of attorney that I have given is one in which it's very specific but general in authorization, giving pretty much all power to them. So of course, you want to pick an agent who you can trust, someone that you have a relationship with, someone who is mindful of your interests and what your wants are. And I would also stress that you don't have to be too concerned that they might make unilateral powers, because the agent who receives these powers have what's called a fiduciary duty. They just can't take your money and spend it and go to Las Vegas or to go to Marrakesh. They have to make sure that this money is being spent as their authorization dictates for what your interests are, what your responsibilities are. They cannot use it for themselves. Otherwise, they would be what's called breaching their fiduciary duty, and then they could be brought up on charges for it. So obviously, you want to pick someone who you could trust and someone that is financially has the acumen and the skill set to handle bill paying. But it is, again, an incredibly important document, not just for the elderly, but even for the middle-aged and for the young. Any adult who might have a decision that they make themselves and possibly cannot for circumstances we've discussed should have an agent who can make it for them.
David, again, is the spouse a natural right holder to make those decisions, or you need this power of attorney to make those decisions?
That's a really great question, once again, because oftentimes spouses believe that they have every inherent right. Now, certainly, if there's an account that's in joint name, then both husband and wife who are account holders have access to that money in full. Each of them can spend the money as they see fit, and the entirety of that account, if it's a joint account, would be able to be managed and bill paying and spending by each of them. But the inherent right of a spouse to be authorized to make all kinds of other decisions for the other, they do not have that inherent right. Only with a power of attorney do spouses have the right to be an agent, and specifically for the property and for the financial assets that are not in joint name.
David, we will continue. ਅਸੀਂ ਇਹ ਗੱਲ ਜਾਰੀ ਰੱਖਾਂਗੇ ਇੱਕ ਛੋਟੀ ਜੀ ਬ੍ਰੇਕ ਦੇ ਬਾਅਦ। ਤੁਸੀਂ ਦੇਖਦੇ ਰਹੋ ਦ ਵੇ ਫਾਰਵਰਡ। ਦ ਵੇ ਫਾਰਵਰਡ ਵਿੱਚ ਤੁਹਾਡਾ ਫਿਰ ਤੋਂ ਸਵਾਗਤ ਹੈ। ਮੈਂ ਤੁਹਾਡਾ ਹੋਸਟ ਹਰਜੋਤ ਸਿੰਘ। ਤੇ ਬ੍ਰੇਕ ਤੇ ਜਾਣ ਤੋਂ ਪਹਿਲੇ ਜੱਜ ਸਾਹਿਬ ਨੇ ਦੱਸਿਆ ਕਿ ਜਿਵੇਂ ਮੈਡੀਕਲ ਡਿਸੀਜਨਸ ਲੈਣ ਵਾਸਤੇ ਸਾਡੇ ਕੋਲ ਹੈਲਥ ਪ੍ਰੋਕਸੀ ਹੁੰਦੀ ਹੈ, ਉੱਦਾਂ ਹੀ ਜਿਹੜੀ ਫਾਈਨੈਂਸ਼ੀਅਲ ਡਿਸੀਜਨਸ ਹਨ ਉਸ ਵਾਸਤੇ ਸਾਨੂੰ ਪਾਵਰ ਆਫ ਅਟਰਨੀ ਚਾਹੀਦੀ ਹੈ। ਜਿਹੜਾ ਤੁਹਾਡਾ ਸਪਾਊਸ ਹੈਗਾ, ਹਸਬੈਂਡ ਜਾਂ ਵਾਈਫ, ਉਹ ਨੈਚੁਰਲੀ ਹਰ ਚੀਜ਼ ਦਾ ਤੁਹਾਡਾ ਡਿਸੀਜਨ ਨਹੀਂ ਲੈ ਸਕਦਾ। ਆਪਾਂ ਸੋਚਦੇ ਆ ਕਿ ਕਿਉਂਕਿ ਉਹ ਸਪਾਊਸ ਹੈ ਉਹ ਹਰ ਡਿਸੀਜਨ ਲੈ ਸਕਦਾ ਹੈ। ਸਿਰਫ ਉਹ ਅਕਾਊਂਟਸ ਜਿਸ ਦੇ ਵਿੱਚ ਤੁਸੀਂ ਜੁਆਇੰਟ ਦੋਨੋਂ ਅਕਾਊਂਟ ਹੋਲਡਰਸ ਹੈਗੇ ਹੋ, ਭਾਵੇਂ ਉਹ ਬੈਂਕ ਦੇ ਅਕਾਊਂਟ ਹੋਏ, ਭਾਵੇਂ ਉਹ ਪ੍ਰਾਪਰਟੀ ਹੈ ਜਿਸ ਦੇ ਤੁਸੀਂ ਜੁਆਇੰਟ ਹੋਲਡਰਸ ਹੋ, ਉਸ ਦੇ ਵਿੱਚ ਤੇ ਸਪਾਊਸ ਤੁਹਾਡਾ ਡਿਸੀਜਨ ਲੈ ਸਕਦਾ ਹੈ। ਬਟ ਬਾਕੀ ਜਿਹੜੇ ਤੁਹਾਡੇ ਪਰਸਨਲ ਐਸੈਟਸ ਹੈਗੇ ਉਸ ਵਾਸਤੇ ਤੁਹਾਨੂੰ ਇੱਕ ਪਾਵਰ ਆਫ ਅਟਰਨੀ ਚਾਹੀਦੀ ਹੈ। ਇਸ ਕਰਕੇ ਅਗੇਨ ਬਹੁਤ ਜ਼ਿਆਦਾ ਜ਼ਰੂਰੀ ਹੈ ਕਿ ਤੁਸੀਂ ਜਿੱਥੇ ਇੱਕ ਹੈਲਥ ਪ੍ਰੋਕਸੀ ਰੱਖਦੇ ਹੋ ਉੱਥੇ ਹੀ ਇੱਕ ਪਾਵਰ ਆਫ ਅਟਰਨੀ ਨੂੰ ਵੀ ਅਪਾਇੰਟ ਕਰਨਾ ਕਿਸੇ ਵੀ ਵੇਲੇ ਕੁਝ ਵੀ ਹੋ ਸਕਦਾ ਹੈ। ਇਹ ਜਿਹੜੀ ਕੈਪੈਸਿਟੀ ਹੈ ਤੁਹਾਨੂੰ ਕਿਸੇ ਨੂੰ ਦੇਣੀ ਪਏਗੀ ਕਿ ਉਹ ਤੁਹਾਡੇ ਵਾਸਤੇ ਫਾਈਨੈਂਸ਼ੀਅਲ ਡਿਸੀਜਨਸ ਲੈ ਸਕੇ। David, these are two very important instruments you taught us about. The third most important thing is will. And we encourage everyone to have a will. But can you tell us what exactly is a will and what are its shortcomings?
Absolutely. So, agreed. Everybody should have a will, but there will be a caveat when we get into another area shortly. But a will is an absolutely necessary document. So let's just talk about someone who dies without a will. If somebody dies without a will and they have property, they have assets, they have homes, someone on their behalf, and it's not a designated person because there's no will that designates them, but oftentimes it's a spouse or a child, would then have to file what's called administration papers. Someone who does not have a will is referred to as having died intestate, 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 which basically means without a will. The process of going through that administration is a very lengthy one. It's also a very costly one, not just court filing fees, but also attorney's fees, because then the court has to make determinations as to what is the ultimate rights of the beneficiaries. There are automatic rights. The surviving spouse has a certain percentage and dollar amount that they're automatically entitled to. And once again, sometimes the deceased spouse didn't want to leave them that amount. Possibly they wanted to leave more or they wanted to leave less. But without a will, they have no authority, the court, to make any determination other than what's under the laws of intestacy. So
David, I'm sorry. Let me ask you this. This is a very popular question in the community. If somebody dies intestate, does everything goes to the spouse?
It does not. There's a certain percentage that they get depending on how many children, and a lump sum figure of $50,000. So if by chance the only asset is $50,000, the spouse could very well receive that entirety when the deceased spouse wanted to leave for the children. Just to make things more complicated, sometimes you have first and second marriages. So you have children from different marriages, and therefore there's no automatic right. And the idea of, well, if the spouse receives the whole amount, eventually it would then fall down in the chain to those very children. It might not. So again, wills are not expensive to do. It's not a very lengthy process. The will encompasses many provisions. Some are boilerplated, but certainly there are others that are specific, in which you devise, you leave real property to those who you wish to. You leave personal property to those that you wish to. You can also make funeral and burial provisions, specifically stating, upon my death, this is who I want to, this is where I want to be buried. Sometimes people, especially in cultures such as yours and mine, we have a lot of people who are indeed not intend to be buried here in the United States, but want to be buried in their motherland. So those types of provisions also would be identified and listed in a will.
David, I'm sorry. Just one more clarity in a situation where there is no will.
Yes.
Is there a chance that the family does not get anything, that everything goes to law, or is so heavily taxed that the family doesn't benefit? Is there a situation?
There is not. The only thing that I would strongly urge is that anyone who says, well, it's going to go to the family anyway, so why do I need to spend money on a will, would be reminded of the fact that whatever they end up spending on the lawyer to draft the will be pennies relative to the cost of going through the administration process. Going through the administration process is not easy. You need a lawyer to do that if you have certain net worths or certain assets. It cannot be done just by an unrepresented party. The court will require, if the assets are large enough, to hire an attorney. And ultimately, the cost that you're going to try and save by not having a lawyer, you will be spending insofar as having to go through that process. There's also one other element of this, which is timing. Oftentimes, you have property upon death in which the surviving spouse or family members want to convey and transfer that property to someone else. There's just too much emotional baggage in maintaining that property. They want to sell it. They want to transfer it. Without the authority by the court to allow you to, that property can stay in the family name. All of the taxes, all of the running charges and carrying charges for that property will have to be maintained by the surviving children. And until there's authority to have the money that the decedent, the person who died, transferred over, sometimes the family members have to utilize their own money to be able to pay those charges that are presently incurring. Not something that people are necessarily so comfortable in doing. Of course, they'll have the right, ultimately, when the administration process is complete, to be paid back. But once again, and oftentimes, the terminology or the phrase is penny wise, pound foolish. To save money by not doing a will, you will indeed spend that money through the administration process. But to answer your question, there is no law that says that without a will, everything goes to the government, everything goes to the state. There is not that. Unless, of course, somebody dies without beneficiaries that are automatic, such as surviving spouse, children, siblings. If somebody dies without a family unit, then the state has to ultimately, or the surrogate court has to ultimately determine, well, who's entitled to this? And one more thing that I just want to add. Yeah. If indeed there is bills, there's creditors, they certainly can put a lien on the estate. Putting that lien on the estate because somebody died with debt owed to them, that makes the process even lengthier. So an administration process where people want to pay off the creditors as the survivors of the person who died, the process is just so much more tenuous, so much more hard, difficult, time-consuming in an administration process versus, of course, in a testamentary where somebody has a will and therefore their wishes are carried out accordingly.
David, we'll continue this after a short break. ਤੁਸੀਂ ਵੇਖਦੇ ਰਹੋ The Way Forward. The Way Forward is ਤੁਹਾਡਾ ਫਿਰ ਤੋਂ ਸਵਾਗਤ ਹੈ। ਮੈਂ ਤੁਹਾਡਾ ਹੋਸਟ ਹਰਜੋਤ ਸਿੰਘ। David, I will take a small clarification from you. You see, as I said, we are still a new immigrant community in this country, and there are a lot of families where there's only one member present here and rest of the family is in India. So if that person has to appoint a health proxy or a power of attorney, can they appoint somebody sitting outside the country?
They can. In the healthcare proxies, as well as the powers of attorney, not only do we list the person who is the agent, we list their address, but that we also list the phone number. As long as it is satisfying all the statutory requirements, the doctors are still empowered and authorized and directed to reach out to that next of kin. If that person happens to be in Mumbai, they'll have to contact Mumbai.
Sure. I'll break this down for a community. ਦੇਖੋ ਇਹ ਜਿਹੜਾ ਹੈਲਥ ਪ੍ਰੋਕਸੀ ਹੈ, ਪਾਵਰ ਆਫ ਅਟਰਨੀ ਹੈ, ਇਹ ਤੁਸੀਂ ਕਿਸੇ ਨੂੰ ਵੀ ਬਣਾ ਸਕਦੇ ਹੋ। ਜ਼ਰੂਰੀ ਨਹੀਂ ਹੈ ਕਿ ਉਹ ਯੂਐਸ ਵਿੱਚ ਰਹਿੰਦੇ ਹੋਣ, ਯੂਐਸ ਦੇ ਸਿਟੀਜ਼ਨ ਹੋਣ ਜਾਂ ਗ੍ਰੀਨ ਕਾਰਡ ਹੋਲਡਰ ਹੋਣ। ਇੰਡੀਆ ਵਿੱਚ ਬੈਠੇ ਦੇ ਵੀ ਅਗਰ ਤੁਹਾਡਾ ਕੋਈ ਫੈਮਿਲੀ ਮੈਂਬਰ ਹੈ ਔਰ ਤੁਸੀਂ ਚਾਹੁੰਦੇ ਹੋ ਕਿ ਡਿਸੀਜਨ ਉਹ ਲੈਣ ਐਸੇ ਮੌਕੇ ਤੇ ਤੁਸੀਂ ਉਹਨਾਂ ਨੂੰ ਬਿਲਕੁਲ ਉਹ ਜਿਹੜੇ ਪਾਵਰ ਆਫ ਅਟਰਨੀ ਜਾਂ ਹੈਲਥ ਪ੍ਰੋਕਸੀ ਅਪਾਇੰਟ ਕਰ ਸਕਦੇ ਹੋ। ਤੁਸੀਂ ਆਪਣੇ ਵਿਲ ਵਿੱਚ ਵੀ ਜਿਹੜੀ ਪ੍ਰਾਪਰਟੀ ਹੈ ਉਹ ਵੀ ਕਿਸੇ ਨੂੰ ਵੀ ਦੇ ਸਕਦੇ ਹੋ। ਇਹ ਅਸੀਂ ਫਰਦਰ ਡਿਸਕਸ ਕਰਦੇ ਹਾਂ। ਪਰ ਜਿਸ ਪੁਆਇੰਟ ਤੇ ਪਹਿਲੇ ਆਪਾਂ ਲਾਸਟ ਬ੍ਰੇਕ ਕੀਤੀ ਸੀਗੀ, ਡੇਵਿਡ ਦੱਸ ਰਹੇ ਸੀਗੇ ਕਿ ਤੁਸੀਂ ਅਗਰ ਵਿਲ ਨਹੀਂ ਕਰਦੇ, ਤੁਹਾਨੂੰ ਇੱਕ ਪ੍ਰੋਸੈਸ ਜੇ ਐਡਮਿਨਿਸਟ੍ਰੇਸ਼ਨ ਦਾ ਪ੍ਰੋਸੈਸ ਹੁੰਦਾ ਹੈ ਉਹ ਕਰਨਾ ਪੈਂਦਾ ਹੈ। ਉਹ ਸਾਰੀ ਪ੍ਰਾਪਰਟੀਜ਼ ਅੱਗੇ ਵੇਚਣ ਵਾਸਤੇ ਜਾਂ ਉਸ ਨੂੰ ਪ੍ਰੋਪਰਲੀ ਆਪਣੇ ਨਾਂ ਤੇ ਲਿਆਉਣ ਵਾਸਤੇ। ਉਹ ਜਿਹੜਾ ਪ੍ਰੋਸੈਸ ਹੈਗਾ ਉਹ ਬਹੁਤ ਲੰਬਾ ਹੈਗਾ ਔਰ ਉਸਦੇ ਬਹੁਤ ਪੈਸੇ ਲੱਗਦੇ ਨੇ, ਕੋਰਟ ਦੀ ਕਾਸਟ, ਵਕੀਲਾਂ ਦੀ ਖਰਚਾ। ਇਸ ਕਰਕੇ ਬਹੁਤ ਜ਼ਰੂਰੀ ਹੈ ਕਿ ਤੁਸੀਂ ਇੱਕ ਵਿਲ ਬਣਾਓ ਜਿਹੜਾ ਇਸ ਸਾਰੀ ਚੀਜ਼ ਨੂੰ ਬਹੁਤ ਆਸਾਨ ਕਰ ਦਿੰਦਾ ਹੈ। ਨਹੀਂ ਤੇ ਸਾਰੇ ਉਹ ਕਾਨੂੰਨ ਹੈਗੇ ਕਿ ਅਗਰ ਕਿਸੇ ਬੰਦੇ ਦਾ ਵਿਲ ਨਹੀਂ ਹੈ ਤੇ ਕਿਸ ਦੇ ਹੱਥ ਵਿੱਚ ਕੀ ਪ੍ਰਾਪਰਟੀ ਆਣੀ ਚਾਹੀਦੀ ਹੈ, ਇੱਦਾਂ ਦੇ ਕਾਨੂੰਨ ਬਣੇ ਹੋਏ ਨੇ। ਬਟ ਉਨ ਕਾਨੂੰਨ ਨੂੰ ਇੰਪਲੀਮੈਂਟ ਕਰਨ ਵਾਸਤੇ ਜਿਨ ਤੁਸੀਂ ਵਕੀਲਾਂ ਨੂੰ ਹਾਇਰ ਕਰਦੇ ਹੋ ਔਰ ਜਿਹੜੇ ਕੋਰਟ ਦਾ ਪ੍ਰੋਸੈਸ ਹੈ ਉਹ ਬਹੁਤ ਮਹਿੰਗਾ ਔਰ ਬਹੁਤ ਲੰਬਾ ਤੇ ਔਖਾ ਵੀ ਹੈਗਾ। ਡੇਵਿਡ, you were telling us about the wills. Is will the best way to transfer your property after you're no more living?
So that's really a great question and a complicated question, and it certainly bears on the case-by-case basis. For some, the will is the less costly and the instruments that will meet the parties who come into our office and say, this is what we want to do, because this is what not only we want to spend, but we're not concerned about the timing of the court system when a husband and wife both own a property. And look, sometimes, unfortunately, there's tragedy and disaster that is not something foreseeable, and there is simultaneous passing, car accidents and the like. But usually, one spouse passes before the other spouse passes. So property that's in both their names, once one spouse passes, it obviously, under the deed, becomes the property of the other. So when clients say, we want to have a will and we're prepared to understand the timing and the cost with the court system of probating the will, then we certainly are not going to talk them out of it. But we do have many clients who choose otherwise, and for good reason. We have those who decide that they want to do what's called irrevocable trust, that they want to start transferring their property into a trust for purposes of making sure that it doesn't have to go through the probate process, that it already has been transferred into a family trust, so that without the court system designating and allowing for the transference of the property, the trustee, like an agent, the person who is authorized to then sell the property, transfer the property, lease, rent the property, has that authority to do so. And for the people who come to us who are the elderly, remember, trust and estates in part is also elder law. We do a lot of work for the elderly, 65 and above. For those who cannot afford, and many are included, myself is included, long-term care insurance is one of the most costly insurances out there. Securing a policy that will give you long-term care to be able to be in a facility, in a nursing home, in a skilled facility, we're talking about what could very well be thousands or tens of thousands of dollars per year, and over the lifetime, it could be hundreds of thousands of dollars that you're paying in a policy. So what do people do? Because they can't afford it, or because they realize that the limitation on that long-term care is also limiting. They should not call it long-term care, they should call it limited care. Because what they oftentimes do, these insurance companies, is they give you a per-day allowance. My mother, who unfortunately had a stroke, has long-term care. It's $150 a day. You go into a facility now in New York, the cost of that care could be upwards of $400 to $500 per day, which if you calculate over the course of a year's time times 365, this could be $150,000 per year. Nothing close to what my mother has insofar as long-term care. So if you don't then do some kind of planning, you're going to be out of pocket a lot of money. So what do people do? They transfer their properties into a trust for purposes of then ultimately going on Medicaid. there is a misunderstanding when it comes to Medicaid. Now, we'll talk about Medicare in a moment, but Medicaid oftentimes is referred to as insurance for the poor. And it is true that people on public assistance are usually on Medicaid. But Medicaid is also available to seniors who meet certain criteria when it comes to their assets. We have people who have multiple homes, who have businesses, who have lots of assets of liquid as well as non-liquid, whether we're talking about bank accounts and securities, and they transfer a lot of this property into their trust, into the family trust, and then they become Medicaid eligible. And this is all not only authorized, but this is exactly what the Medicaid for Senior plan is specifically for, to allow those seniors to be able to then have Medicaid as an alternative. They can then get either access to facilities, or as many people wish, they want to stay in their homes. And through the Medicaid plan, you can then have what's called community Medicaid, which is where you have home health attendants through the Medicaid program who will come to the home for a certain amount of hours. Some actually need 24/7 care for all of their necessaries because they're not able to handle any of their particular needs, whether it's food or bathing or toileting or medication dispensing. And they will be able to have, through the Medicaid program, someone who's able to come to their home. So it is not just for the rich, it is for those who think ahead and ultimately realize the cost of not doing that type of care.
David, at the top of the program, I said that we'll talk about the benefits that they're there for seniors, under elder law and Medicare and all that. But I think this particular thing, it's so sophisticated and so important that it needs an entire episode. We will request you to come again and talk about that at length. I hope you'll find time for us. It's very important for the community. It's very important for our viewers. Today, I will, probe a little further into wills, and that's what we'll do. Can you please quickly tell us what's the difference between a probate and administration?
So probate versus administration simply is someone who has a will and someone who doesn't have a will. If someone comes to our office and says, my father died and had no will, then we will ask them for documentation insofar as assets. Did they have a house? Did they have bank accounts? What exactly did they have as part of their portfolio? And then we will file a petition for administration. We're going to the same court and we're asking them to make determinations in the absence of a will to allow for the next of kin. Sometimes we actually have to do some type of research insofar as finding people, diligent searches. We have what's called an affidavit of heirship, where we ask a third party to attest to the fact that they knew the person who passed intimately and well, and be able to attest that the person who is the surviving child is their only child. Because oftentimes the child who comes to the lawyer's office and says, I am the beneficiary, might not be the only entitled beneficiary. So the court does not have all of the information and will require for the lawyers to do a lot of work to be able to provide necessarily and reasonably that which the court system is then comfortable in saying, now this estate can be administered and the assets can now be transferred. When it comes to a will, then you have probate, where you take that original will, and it has to be an original. It cannot be a copy. It has to be signed by witnesses. It has to be notarized. It should be initialed on every page so that the person who passed is identifying each and every page that was their wish. Oftentimes, we've had wills that have been separated by staple. The court will disqualify a will if there's any alteration or if there is a removal of staples, because they have seen everything, including the slipping of one piece of paper that changes a very important provision from what originally was another. So do not take your staples out of your wills once it is stapled. Another very important thing that I want your audience to know is that just because you did a will before does not mean that you can't do a will again. Wills have no legal authority, no legal power until death. You can write 30, 40, 50 wills. The only one that will count is the last one, because it is a superseding document. All the prior ones are superseded by the latest. But you want to then make sure to have it safekept and to put it in a place where it's not going to be susceptible to water or fire or any other damage, and that it could be located by your beneficiaries, by your family members. Because if they can only find the will that might have been will second to the last, that's the one they're going to probate, and might not be what the person who died's wishes were. You want to make sure that the latest will is identified, filed, and then wait for the court system to authorize its designations.
David, we have run out of time today. This is so important. This is so enlightening. I thank you so much, and I really request, I think we'll have to continue this. We'll request you to come to the studios again. Help our viewers. I hope ਸਾਡੇ ਸਾਰੇ viewers ਨੇ ਇਹ ਸਾਰੀ ਗੱਲ closely ਸੁਣੀ ਹੋਣੀ ਹੈ। ਸਾਨੂੰ ਅਸੀਂ ਇਸ ਗੱਲ ਤੇ ਇਹ ਗੱਲ ਅਸੀਂ ਜਾਰੀ ਰੱਖਾਂਗੇ, ਕਿਉਂਕਿ ਹਾਲੇ ਵੀ ਬਹੁਤ ਇੰਪੋਰਟੈਂਟ ਚੀਜ਼ਾਂ ਹੈਗੀਆਂ, ਬਹੁਤ ਇੰਪੋਰਟੈਂਟ ਐਸੇ ਐਸਪੈਕਟਸ ਹੈਗੇ ਜੋ ਅੱਜ ਅਸੀਂ ਕਵਰ ਨਹੀਂ ਕਰ ਪਾਇਆ, ਜੋ ਅਸੀਂ ਕਵਰ ਕਰਾਂਗੇ ਅਸੀਂ ਆਪਣੇ ਆਉਣ ਵਾਲੇ ਐਪੀਸੋਡਸ ਵਿੱਚ। David, thank you so much for taking all the time today.
Thank you, and thank your audience for listening.
Sure. ਇਹ ਸੀ ਸਾਡਾ ਅੱਜ ਦਾ ਸ਼ੋਅ। ਤੁਸੀਂ ਵੇਖਦੇ ਰਹੋ The Way Forward।